Hi, everyone. Welcome. My name is Shannon Gleeson, and I am very thrilled to present to you our eCornell keynote speaker for this afternoon. Chiara Galli is an assistant professor at the University of Chicago in the Comparative Human Development Department. She's also a faculty scholar in the American Bar Foundation's Access to Justice Scholars Program. She received her PhD from UCLA and was a postdoctoral fellow here at Cornell through the Klarman program. She's here today to talk about her recent research and her book, Precarious Protections, Unaccompanied Minors Seeking Asylum in the United States, published by University of California Press, which is an ethnographic study that chronicles the experiences and perspectives of Central American unaccompanied minors and their immigration attorneys as they pursue applications for refugee status in the asylum process, a very timely topic. So I'll turn it over now to Chiara. We'll take some questions at the end. Thank you so much for being here.
Thank you, Shannon. Thanks for the invitation to Shannon Gleeson and also to the Cornell Migrations Initiative, which was a wonderful space for me, an intellectual community during my postdoc at Cornell. So it's my great pleasure to be back today to share with you some of the findings from my book, Precarious Protections. So I have some slides that I'll share. All right, here we go. So I want to start the talk today by sharing with you the stories of two of my young research participants, Danny, who fled from Honduras at age 15, and Hector, who fled Guatemala at age 16. Now, the circumstances that each teenage boy escaped were remarkably similar. Both Danny and Hector faced dire and immediate risk. They had both received threats from gang members. And the boys knew that these were not empty threats because these same individuals had murdered their friends, other teenagers like them, only days or weeks before. Both boys made it out alive due to sheer luck. For Hector, it was thanks to his friend's mother, who had already paid the Coyotes fare to smuggle out her own son when he was killed by the same gang members threatening Hector. She called him and urged him to use the Coyotes fare to make the journey himself and save his life. For Danny, it was because he just so happened to be friends with a coyote who smuggled him out for free as a personal favor when he learned his friend's life was at risk. Both boys migrated to the US as unaccompanied minors, hoping to find protection and support with their undocumented relatives who were already living here at the time of their migration. Both boys applied for refugee status in the US asylum process, a system so rife with uncertainty that a famous study nicknamed it the refugee roulette. Both boys were represented by an immigration attorney, and in fact, they were represented by the same organization, the nonprofit organization that helped prepare their case. Both boys took their chances in the refugee roulette, but only Danny was protected. So Precarious Protections tells the stories of kids like Danny and Hector who fled Central America alone as teenagers, arriving in the US during the Obama and Trump administrations. And as you can see, this is a phenomenon that since we've started keeping track in 2009 has been increasing steadily almost every year. It describes how these children navigate the US asylum process with the help of nonprofit attorneys. And in the past 12 years, over 750,000 kids like Danny and Hector have arrived at the US-Mexico border. Based on their circumstances of migration, I consider kids like Danny and Hector to be de facto refugees. In other words, individuals who escaped life-threatening violence. Yet in the book, I show that such circumstances of migration are by no means sufficient to guarantee that they'll be granted refugee status. Even though unaccompanied minors are a formally protected category who benefit from due process protections unavailable to adults in the US asylum process, their lived experiences nonetheless too often fail to satisfy the formal refugee definition as it is narrowly interpreted in this country. Past quantitative scholarship has documented biases in how asylum decisions are made and significant disparities in asylum grant rates across immigration courts and asylum offices located in different parts of the US, and even among decision makers in the same agency. Because the asylum process is so rife with indeterminacy, my goal with the book wasn't to develop some grand theory to predict case outcomes. In other words, why some kids are granted asylum and others are not. But rather, I was interested in examining how nonprofit immigration attorneys use their expertise and legal strategies to mitigate risk and improve their young clients' chances of success in the asylum process by trying to bridge the gaps between youth's lived experiences and narrow US refugee law. And yet, as we will see, despite advocates' best efforts, too many vulnerable kids like Hector, who escaped life-threatening violence in Central America, are denied the protection that they seek and that our laws promise. So I want to tell you about two of the contributions to existing scholarship and academic debates. So past ethnographic scholarship on immigration lawyering has focused mainly on the case of adults. And scholars have argued that lawyers play a legal translation role that make it possible for immigrants to interact with and be legible to the state as they claim rights. Now, due to teenagers' unique developmental characteristics, this role is even more essential when it comes to lawyering with unaccompanied minors, and it's even more challenging for lawyers to work with this population. Furthermore, when it comes to helping youths apply for humanitarian forms of deportation relief like asylum, the legal translation role that lawyers play is especially complex. So to explain how lawyers translate migrants' experiences of suffering so they can be mobilized to obtain tangible benefits of refugee status, I introduce the concept of humanitarian capital, defined as a form of symbolic capital that lawyers activate relationally as they interview their immigrant clients by recognizing specific instances of suffering in their lived experiences and granting different levels of value to each. So for unaccompanied minors, it is those experiences that signal them as vulnerable dependent children that hold more value than others, giving rise to all sorts of paradoxes that I'll tell you about today. Lawyers assess humanitarian capital by comparing their clients' experiences both to legal definitions and to other cases they've worked on in the past. And keep in mind that it's pretty difficult for them to learn from past experiences because the asylum office actually does not provide written explanations to detail why a specific case was granted or denied. So actually there's a good amount of guesswork in addition to legal expertise that goes into this kind of lawyering. By assessing humanitarian capital, lawyers decide what cases to represent, what forms of relief to pursue, and they estimate the likelihood of success for each applicant by trying to anticipate whether the asylum officer will grant or deny the case and make a discretionary decision on this outcome. They make migrant suffering legible to adjudicators by meticulously documenting in written declarations supported by documentation, usually packets that are many, many pages long, human suffering, emotions, and inherently imperfect memories of past experiences. Now, the second intervention of the book is to the study of how children adapt to host countries, immigrant children, adapt to host countries like the United States, which is a topic of scholarly inquiry that's really been the domain of scholars of assimilation, who've identified acculturation as one of the key mechanisms that leads to positive outcomes like educational attainment or socioeconomic mobility. So acculturation is this idea that children become Americanized and they acquire these English language skills and cultural values. So unaccompanied minors' experiences in the United States differ from the assimilation model in some pretty important ways. In this model, acculturation is a process of social learning that takes place slowly over time, emerging from everyday interactions that take place largely in inclusive institutions like the K-12 public education system. Now, unaccompanied minors who arrive as older teenagers in the US don't get to spend a lot of time in K-12. But on the other hand, they interact very intensively with the immigration bureaucracy from the very moment when they first step foot on US soil. And they're socialized quickly as they navigate a maze-like legal process and pursue asylum applications that require specific knowledge of complex immigration laws that lay people typically don't possess. So taking these differences into account, I shift attention away from the processes of acculturation that have been the focus of past scholarship to instead propose the analytic lens of legal socialization that I borrow from research in criminology. So you can see it defined on the slide. So legal socialization occurs through interactions in institutions based on rules and relationships of authority. And while learning about the law is an important part of growing up in society, this has really been neglected in studies of immigrant children's adaptation. So most studies of legal socialization have focused, for instance, on how Black children are socialized vis-a-vis their interactions with institutions of policing. So in my book, I trace how the legal socialization of unaccompanied minors takes place as they interact with immigration bureaucrats and with their immigration attorneys, who help them navigate these unfamiliar state systems and understand complex laws. As we will see today, learning about the law is crucial for kids' chances of success in the US asylum process. And yet, despite lawyers' best attempts to teach kids about the law, many knowledge gaps persist, and the asylum process remains a largely disempowering one for these children, who learn far more about the risks they face due to punitive immigration enforcement rather than about their rights as a protected category under US immigration law. So to write this book, I spent over 4 years conducting ethnographic fieldwork in various nonprofit migrant-serving legal aid organizations in Los Angeles. In these organizations, I shadowed immigration attorneys and other staff as they helped almost 80 Central American unaccompanied minors apply for asylum and for SIJS, or Special Immigrant Juvenile Status, which is a form of deportation relief for children who've been abandoned, abused, or neglected by one or both of their parents. In these same organizations, I was essentially trained as a volunteer paralegal. So I was really an active participant in the process that I was studying as well. I complemented the ethnography by conducting over 120 interviews with unaccompanied minors from El Salvador, Guatemala, and Honduras, their immigration attorneys, their family members, and other key actors in the process. The research spans and compares the Obama and Trump administrations, and I'll tell you a little bit about what changed in these two legal and political contexts during today's talk. So before I delve into the findings, I just wanted to tell you a little bit about the broader scope of the book with an outline of its contents. So Chapter 2 is set in Central America, and it describes how youths make migration decisions in contexts of violence. Chapter 3 describes how youths experience detention in the infamous cages at the US-Mexico border, which I'm sure you've seen in the news, and in the so-called shelters run by the Office of Refugee Resettlement, which are essentially detention facilities for unaccompanied children. In Chapter 4, I describe youths' first encounters with the immigration court system and the challenges involved in finding an attorney in this country where there is no public defender system in immigration court, and not even indigent children are guaranteed a free immigration attorney. And while there is some public funding for legal aid organizations like the one that represented Danny and Hector, the demand for legal services from children far outpaces the available supply of nonprofit legal service providers. Today, I'll share with you findings from Chapter 5 that traces how attorneys help kids apply for asylum and SIJS. Chapter 6 of the book zooms out, discussing how the legal process spills over to influence other facets of the youth's lives as they navigate school, work, and family reunification. And in the conclusion, I offer some policy recommendations for humane immigration reform. So lawyers use various legal strategies to bridge the gap between youth's lived experiences of escape and the narrowly interpreted formal refugee category. As one of my attorney respondents put it poignantly during her interview, She said, asylum law does not make common sense. I had more than one case where the thing that pushed them out the door wasn't what made their case winnable. I'm starting to feel a little nervous saying that because I think it plays into the narrative that this administration's trying to push, that asylum claims are somehow fraudulent, that people are asking for asylum on a basis that's different from what brought them here. But to me, instead, it exposes the illogic of asylum law, that a person can be legitimately terrified and a child can have every right to claim a safe place to live from a common sense perspective, but not from a legal perspective. Now, the lawyer's cautious attitudes in making these remarks reflects just how hard it was to work in a context as an asylum attorney, in a context where President Donald Trump himself demonized asylum lawyering as, I quote, a big fat con job, end quote. And indeed, the legal strategies that attorneys use to bridge the gap between youth's lived experiences and the refugee category are often misconstrued as problematic or unethical lawyering. And yet the legal framing of asylum narratives is in fact indispensable to help kids like Danny, who escaped from violence, to win asylum because of the very narrow ways in which we interpret refugee law in this country. So what does that mean in practice? So to satisfy the refugee definition, which you can see defined on the slide in the orange box, all asylum seekers, including children, must show that they experienced the right amount of suffering and victimization in their home countries prior to their escape. This needs to be enough to rise to the level of persecution, a legal criterion that is inherently ambiguous and has actually not been legally defined, and hence discretion plays a big role in these decisions in deciding how much suffering, or to use the conceptual vocabulary that I use in the book, just how much humanitarian capital is enough to merit refugee status. These decisions are subject to a lot of interpretation. Secondly, asylum seekers must also show that they experience the right types of suffering. To qualify for asylum, individuals must have been persecuted because one of the 5 protected grounds in the refugee definition, race, religion, nationality, membership in a political social group, in a particular social group, excuse me. And Central American unaccompanied minors usually apply for asylum under this particular social group, or PSG grounds, a very ambiguous eligibility category, the interpretation of which is being constantly redefined through a US asylum case law. Now, for children from Central America, the case law sanctions only 2 PSGs, or 2 types of suffering, as really eligible for asylum. So the best cases to yield humanitarian capital were cases of either child abuse or domestic violence, and cases based on family ties. In other words, when the child was persecuted because of their relationship with a family member. During most of my fieldwork, these were the 2 types of cases likely to be granted. So essentially, for children, US asylum case law validates only those experiences of escape that reify notions of childhood as a state of vulnerability because of children's lack of agency and dependency on adults. And this is really interesting because it's very different to how we interpret asylum law for adults, who must instead show that they were really targets, the primary targets of the persecution. Now, on the other hand, US asylum case law has long been unfavorable, to cases based on gang violence, both forced recruitment, which is a very common scenario that teenagers face in Central America, and also some gang involvement. So again, these are common reasons that teenagers flee, as we saw in the cases of Danny and Hector at the start of the talk. These experiences do not yield humanitarian capital and are likely to be denied unless attorneys can find ways to reframe them to fit other legal arguments. So asylum law plays out in some pretty paradoxical ways when it's implemented in practice. In a system that rewards certain types of suffering rather than the need to escape life-threatening violence, case outcomes can play out in some frankly pretty cruel and arbitrary ways. So a good example of this that came up often during my fieldwork were the cases of certain siblings. Now, the way this usually worked is that the usually older sibling who was directly targeted by gang members was far more at risk of being denied asylum than his usually younger sibling who had not been targeted directly. And this was because the younger sibling could claim asylum based on this family particular social group. He was harmed because his brother was being targeted. But the only argument the older sibling could claim was an argument based on gang recruitment, which is not a valid type of suffering. And so we have this outcome where the youth who's directly targeted and hence most likely at risk is also the one who's least likely to obtain protection and refugee status. Now, secondly, the timing of youth's escape was really key in shaping asylum outcomes. In chapter 2 of my book, I really theorize about how youths make migration decisions in contexts of violence and how families on both sides of the border help plan youth's escape by leveraging resources and information in their migrant networks to extract their children from harm. Now, preemptive flight is, of course, the best option for children's well-being, to shield them both from immediate harm and the enduring traumatic effects that some of these experiences can have. And yet, preemptive flight poses key challenges in the U.S. asylum process if children have not accumulated enough experiences of suffering that their attorneys can use to build humanitarian capital and convince asylum officers that this is enough to meet this threshold of persecution. So let me give you a concrete example of this. So Diego was 16 years old when he migrated from Honduras after witnessing a gang member shoot and kill his best friend during a birthday party. The gang member threatened to kill Diego too because he was a witness if he did not leave the country. Diego immediately went into hiding at a relative's house while his mother quickly put together enough money to pay for his trip with a coyote. Now, after hearing Diego recount his story of escape at one of the legal clinics where I did my fieldwork, I was quite surprised when the attorney recommended that he apply not for asylum, but for SIGIS. When I asked her why, she explained, quote, if he had a really strong asylum case, then he could apply for that, but he just witnessed the death, end quote. So the attorney's rationale was not just that Diego experienced the wrong type of suffering, gang violence, one that couldn't be translated into humanitarian capital for asylum, but also that there was nothing to show that the gang member could have found Diego to carry out the threat. The attorney explained, quote, if the gang member had gone to Diego's house to look for him, the case would have been stronger. But since Diego left, it'll be difficult to argue that he was at risk because we just don't know what would have happened if he had stayed. Now, of course, the terrible catch-22 here is that if youth stay too long, they may very well be killed. Now, instead of asylum, Diego went on to apply for SIGIS based on parental neglect. He had started working in first agriculture and then construction from a very young age to help support his family. And these experiences of underage labor qualify youths for this form of immigration relief. While Diego's mother was framed as the negligent parent for the purposes of his SIGIS application, it is clear that she was anything but neglectful, since she immediately took care to extract her son from life-threatening violence by helping to plan his escape. And yet these decisions that loving and protective caretakers make, decisions I think any parent would make in that situation, end up playing out in paradoxical ways by positioning youths more unfavorably in the US asylum process. So to bridge the gap between youth's lived experiences and legal categories, immigration attorneys use various legal strategies. First, as we just saw in the case of Diego, when their clients escape from violence but experience the wrong type of suffering, attorneys encourage them to apply for SIGIS instead. And these decisions were pretty confusing for youths. As one attorney explained, he said, quote, "It's hard for some clients to understand why we're bringing a CIGIS case, saying that their father, who they don't really know or care about, abandoned them. They're like, why are we making this about my dad? If I go back, the gangs will kill me." Second of all, attorneys presented as many legal arguments as they could come up with to justify why the persecution had taken place. And this was a means to maximize chances of success in hopes that the asylum officer would pick at least one and grant the case. But this also had some unintended consequences, because since the asylum office doesn't provide written explanations of why cases are granted or denied, attorneys didn't know which had been successful arguments. So this kind of contributed to the overall uncertainty of this legal process. Third, asylum officers also emphasized eligible elements in their young clients' narratives, those that fit pre-existing case law, to maximize chances of success. But of course, these kinds of legal strategies had the effect of inherently reifying existing narrow and infantilizing interpretations of US asylum law. Now, lawyers could and sometimes did file cases based on new arguments with the goal of trying to expand these eligibility categories so more people would qualify for these forms of relief. But this was risky for youths for whom case denials could mean deportation back to danger in their home country. So the Trump administration introduced a long list of restrictive changes to policies affecting unaccompanied minors and asylum seekers, and did so at such a rapid-fire pace that this had the effect of making an already indeterminate legal context increasingly volatile. Challenging these exclusionary policies required massive amounts of work from organizations involved in impact litigation, and many of these battles were actually ultimately successful in safeguarding existing protections. However, while impact litigation was pending, I saw how youths whose cases were pending in the system experienced the negative consequences of this increasingly exclusionary legal context. And I saw how the work of the direct representation attorneys who I was shadowing became much more challenging. Attorneys had to continuously refashion their legal strategies to find new ways to mitigate and diversify the now heightened risks of case denial and deportation that their young clients faced. So what exactly changed under Trump? I could not possibly tell you everything because the changes were very numerous, and I think a couple of books or more have already been written on the topic, but I'll share with you just 4 key changes that were important for this population. First of all, the eligibility criteria for asylum and CIGIS were interpreted even more narrowly during the Trump administration, which disqualified both domestic violence and family ties as eligible reasons to qualify for asylum. Lawyers perceived these changes as illegitimate and arbitrary, or, quote, really trying to close the door on asylum, end quote. They reacted both by continuing to use Obama-era legal arguments, but also by experimenting much more frequently with new and creative legal arguments than they had done under Obama. And they were able to do so because now essentially every single asylum application had become risky. They hoped these strategies would either lead to expansions of the refugee definition through new case law, a new precedent, or at the very least, their clients' cases would be pending in the system long enough that they might be decided under a new and potentially more favorable administration. Now, secondly, the Trump administration undermined both asylum officers and immigration judges' ability to exercise protective discretion with unaccompanied minors. New hires and supervisory positions at the asylum office that came from an enforcement background meant that officers were now being encouraged to focus on fraud detection while they made decisions on cases, and to treat the cases of children like they did those of adults. So this new culture at the asylum office ran counter to the previous recommendations that asylum officers, especially in LA, had received, which were essentially that they follow the recommendations that they had learned in these trainings, child-friendly asylum interview trainings. And this includes 2 key recommendations meant to accommodate children's unique developmental capacities. First, that children could present less suffering than the bar used for adults, and this could still be considered enough to meet the bar of persecution. And second of all, that children's testimonies need not be held to the same standards of those of adults and could be granted even if they contain some inconsistencies or did not clearly explain eligibility under the 5 protected grounds. Now, before these changes, details were considered key to build humanitarian capital and strong cases. But I observed how following these changes, lawyers reacted by becoming much more cautious about obtaining details from their young clients. They were worried that kids would misremember and misreport something during their interviews. For example, how many people were present or the exact date when they were threatened. So I saw how an absurd balancing act ensued, essentially, where attorneys were now faced with the challenge of preparing cases that were both detailed and vague enough to be granted at the asylum office. Third, under Trump, it became easier for children to age out of special protections under both asylum and SIGIS, creating a hard deadline so that attorneys had to scramble to submit their clients' cases before their 18th birthdays. And this was happening at the very same time as the administration, on its part, was taking longer and longer to decide cases, leaving youths in lengthy legal limbo. Now, not only was keeping up with all of these changes exhausting for my attorney respondents, but each change also prompted new conversations with their clients. I listened to dozens of phone calls where attorneys informed youths about how obscure and highly technical policies could potentially have an impact on their case. Explaining these issues in simple terms was almost impossible for lawyers, who were still themselves trying to figure out and predict how each change might play out in practice. And importantly, as policies change continuously, this crucially undermined youth's ability to learn about the law and understand their rights. But even before Trump, not all unaccompanied minors were equally well-positioned to learn to tell their stories of escape in the language of the law, rather than how they subjectively understood them. But this was a necessary component for their chances of success in the asylum process. So I'll share with you now the examples of 2 17-year-old boys, Edgar, who learned to speak the language of the law and whose case was granted at the asylum office, and Francisco, who failed to do so and whose case was denied. So for Edgar, there was a relatively narrow gap between the subjective way he understood his escape and his eligibility under the law. During his very first meeting with his attorney, he told his story of escape in these terms. He said, quote, "The gang members wanted to kill me because my dad is a police officer," end quote. So Edgar's experiences essentially fit under this family ties PSG. He was targeted because of his relationship with his dad, who was a law enforcement officer engaged in anti-gang policing. Edgar was also an older teenager, and he was relatively more privileged and had spent more time in school compared to many other, or actually most other, unaccompanied minors that I met during my fieldwork. He had never had to work to support his family, and this really showed. Because Edgar was exceptionally articulate, and he had a really critical understanding of the political context in El Salvador that many other unaccompanied minors who were younger and had less formal schooling really lacked. Edgar also had excellent legal representation, and over the course of 5 meetings, lasting several hours each, he and his attorney prepared a strong asylum case based on pre-existing eligible case law. After all these meetings, Edgar learned to state his case even more eloquently than he had been able to do so upon his arrival to the US, and the asylum officer granted him refugee status. Now, Francisco, on the other hand, was an indigenous youth from Guatemala whose asylum case was based on the legal grounds of race and political opinion. And it was denied first at the asylum office and then upon appeal in immigration court. Francisco's case shows that using sophisticated legal arguments can backfire if youths are unable to internalize these arguments and learn to speak about their own experiences in these terms, which of course is even more likely if there's an especially wide gap between their understandings of why they fled and their eligibility under the law. So unlike Edgar, Francisco had very limited formal schooling and had started working as a small child. His family was involved in land rights activism, but because of the very dangerous nature of these activities, they had shielded Francisco from participating or even knowing about these issues. So Francisco had limited access to information that was relevant to his asylum claim. And this was very common among unaccompanied minors. Kids were often unaware of the threats that had been directed at their family members. Family members tend to protect children, right, from this scary information. It had also been near impossible to get in touch with Francisco's family from Los Angeles because to obtain more details to support his case, because there was no phone service in his remote village. And finally, another challenging aspect of preparing asylum cases based on race for unaccompanied minors was that many of these indigenous Central American youths did not have a strong indigenous identity, or even if they did, they didn't identify as a racial minority as we would think about race in the US. Instead, when asked why they were harmed, persecuted, bullied, harassed, they rationalized that it wasn't because they were indigenous, but rather because they were poor. So what you can see here on the slide now is a field note excerpt showing a meeting between Francisco, his attorney, and the paralegal who prepared his case. As you can see, Francisco found it challenging to describe who Ladinos are and why they occupy a privileged position in Guatemalan society. He was puzzled by the legal assistant's reference to skin color and the attorney's remarks on colonialism. The attorney wanted Francisco to articulate an awareness of racial hierarchies in Central America and even a political opinion in opposition to the Ladinos' dominance in society, which is what allows them to steal indigenous lands with impunity and what allowed this individual to target Francisco. The problem is that the lawyer is using a conceptual vocabulary, indigenous rights activism, colonialism, autonomy, that Francisco completely lacked upon arrival. And all these meetings he had with his attorney were not enough for him to gain an understanding of such complex issues. And indeed, Francisco did not fare well in immigration court. The trial attorney representing the Department of Homeland Security convinced the judge to deny his case, making two arguments. First, she said Francisco had not presented enough suffering to rise to the level of persecution, and instead his experiences should be considered, quote, just discrimination. And this was remarkable because Francisco's attorney had taken care to document his humanitarian capital in a declaration that was several pages long and included some pretty gruesome details of abuse and threats. Secondly, the trial attorney argued that race could not have motivated the persecution because the persecutor was a member of the same racial group because he had indigenous relatives. And this second argument really shows you the lack of understanding that the US government has about the sending context in Central America. Unlike the US, where race is constructed in terms of the one-drop rule, in Guatemala, those who intermarry can blend into the dominant Ladino social group, a position of racial privilege that indeed allowed this man to harm Francisco. Because Francisco was ill-equipped to make his case using these complex arguments, he was particularly vulnerable to the attacks of US government officials who are far more interested in trying to remove children than they are in trying to protect them. So to wrap up, attorneys work in nonprofits that have extremely limited resources. Their high caseloads mean they have limited time to teach their clients about the law and their rights. These lessons are complex, and youths who are traumatized and dealing with many other challenges in their lives in the US as newcomers to this country often do not retain this information, right? And as a result, the US asylum process remains a deeply disempowering one for these children. Despite attorneys' best attempts, unaccompanied minors often do not fully understand their rights or the legal strategies that attorneys pursued on their behalf. But what they do internalize is a hyper-awareness of punitive immigration enforcement, this idea that if they make just one mistake, they could be deported. And the words of 16-year-old Linda from Honduras, which you can see on the slide, reflect this. She said, quote, "You have to be really careful. You have to follow the law. There's lots of things that one can't do. Immigration is seeing the things that I'm doing. They have my case number. They have all my information. They know everything I'm doing." So to conclude, under both the Trump and Obama contexts, U.S. asylum law failed to adequately recognize the age-specific forms of persecution and how age shapes exposure to violence in Central American sending countries. As a result, too often, de facto refugee youths are denied refugee status, or they're granted protection under another form of relief, like SIGIS, or for reasons, they are granted asylum, but for reasons that clash quite starkly with their subjective understandings of why they escaped. And this matters because, as we saw in the case of Edgar and Francisco, not all youths are equally well positioned to learn to tell their stories of escape in the language of the law. Indigenous youths, those with limited formal schooling, younger children, and those sheltered by protective caretakers from frightening family histories all face special challenges. Thank you so much for your attention, and I really look forward to your questions.
Thanks so much, Chiara. This was a fantastic presentation, even though it has some really heavy implications for the well-being of these young migrants and others. We have a number of different questions in the chat about the system that you described here, and I wanted to start with one that gets to this question of legal representation in immigration court, which is true, it's a quandary that's true for all migrants, and that we don't have, because it's in the civil system and not the criminal system, Gideon doesn't apply. And so can you say a little bit about how generally people are finding counsel? How do they get access to these resources, either in the private bar or in the nonprofit sphere? And how well is that working?
Yeah, so, this is actually a pretty challenging question to answer because we have very poor data on access to legal representation. The U.S. immigration court data in recent years, because of some changes that the Trump administration made to how the court essentially kept the data, it does not allow us to disaggregate unaccompanied children from adults any longer, ever since 2018. So actually, we don't really have a clear picture in recent years about just how many children were represented. However, based on what we know prior to that change, we do know that unaccompanied minors have higher representation rates than adults in U.S. immigration court. And this has to do with the fact that there's actually more funding for nonprofits that represent children in immigration proceedings. So this is a combination of federal funding, but also a lot of state and local funding. For example, during the time of my fieldwork, the city of Los Angeles had something called the LA Justice Fund, which in that case actually funded both children and adults. So as a result, we know that children's access to legal representation is higher than that of adults. And especially that they're represented by nonprofits at higher rates than adults. So adults tend to be represented by the private bar more often than children. So how do children find legal representation? In a few different ways. So some nonprofits basically have contracts with certain ORR shelters, and they get cases referred to them. And these are cases that are referred essentially on a first come, first served basis. Other nonprofits do these screening interviews where they select clients who they think have strong cases. And so I have in chapter 4 of the book, I talk about some of the problematic implications of these strategies as a means to select children, because these interviews usually take about 10 minutes. And that is just not enough time to get a traumatized child to trust an adult that they're unfamiliar with, to disclose their story, and to really know whether they qualify or not, right? So how do children find these nonprofits? Immigration court is actually a key space where children are connected to these legal resources. There are nonprofit organizations that do legal orientation presentations in these juvenile dockets in court, which are courtrooms that are dedicated to hearing only the cases of unaccompanied minors. And they hand out, these lists of nonprofit organizations. And then it's upon children to call nonprofits and try to get an attorney, try to convince an attorney, basically, to take on their cases. And then one more way that's very important for both children and adults is, of course, migrant networks, right? So people rely on referrals through their networks to connect them both with private attorneys and with nonprofits because they've used those legal services in the past. Of course, those recommendations are not always good, and this sometimes leads kids to be connected with trustworthy attorneys, and other times it leads kids to be connected with notarios. So there's a lot of notario fraud in the immigration process. So people who are not authorized to practice immigration law, taking on these cases with very problematic implications, because this can lead to applications being submitted incorrectly and then cases being denied.
Thanks, Chiara. Another question that came up that has less to do with the bureaucracy and more to do with the social relations of these children and their families. The kind of core of at least SIDGE is this idea that you have a parent who has either abandoned you or mistreated you. And while that might be necessary for the bureaucracy to function, it's oftentimes not always a clear reflection of the situation that these children are facing and the hard choices that their parents are having to make. And so I wonder if you could talk a little bit about the impact of the legal requirements of the immigration bureaucracy and the impact it has on parental and child relationships, and also how do you see unaccompanied minors kind of navigating the tough situation this puts them in, especially if it limits their ability to later petition those parents, so on and so forth?
Yeah, so that's a really important question, and so there's two questions to that. So first of all, how the kids relate to these eligibility criteria of abandonment, abuse, and neglect. So the truth is, most children don't recognize themselves in these legal categories, right? They don't recognize the experience, their familial experience, their relationships with their parents as one that was neglectful or abusive. In some cases they do, but in many cases they don't. And this was most certainly the case of Diego, who's example I shared with you today. And so, we saw a lot of pushback from unaccompanied minors in legal clinics. They did not want to speak poorly of family members who they loved dearly, they were very grateful for having raised them and extracted them from harm, who they were hoping to, support with their remittances. And these were familial ties that in reality, even though the legal status formally severs these ties, they were very much alive, right? And they continued. So then, attorneys had to do the work of convincing kids, explaining, I know you don't want to speak poorly about your mother, but this is for the purposes of your application. It's so you can be granted legal status and be able to remain in the US in a safe way. But the thing that was quite interesting is that despite the fact that there was quite a stark mismatch, again, between the subjective understanding of their experience at home and why they had left and the way they understood their relationship with caretakers and the legal arguments attorneys used, unlike asylum, for SIDGES, kids rarely need to give testimony in family, probate, or dependency court. And so it wasn't as important that they actually learned to speak about their experiences in these terms. As long as the facts were in the declaration, that was enough. And then to the second part of that question, so because SIDGES formally severs this parental relationship with the child, and this is the justification for the state then stepping in to provide support and protection, right, through legal status, this means that kids will forever be ineligible to both reunify parents left behind, and in the case of what is called one-parent SIDGES, if they leave one family member behind or reunify with the other in the US, and that parent is undocumented, they won't be able to legalize their status ever. So attorneys told kids about this limitation to their rights. I saw it many, many times in legal clinics. They explained this. But I found this really disheartening. During my interviews, I met children who had gotten legal status through SIDGs, who had plans to bring their parents to the US through family reunification. So this just shows you, right, some of these knowledge gaps that persist despite attorneys' best attempts to teach kids about the law, right? They had not internalized that information. They hadn't fully realized that getting legal status through this means meant that their parents were not eligible to join them legally in the US.
Yeah. Thank you for that. In the book, you also touch on a number of different kind of diverse experiences that these young people are having in either the SIDG or the asylum process. And one of these cleavages or points of difference is the gendered experiences of these young people. And I wonder if you could touch on a little bit about that and how the young men and women, girls and boys, and others are navigating this in different way or having to weigh certain burdens that may not be universal.
Yeah, that's a great question. I'm always very grateful when someone asks it, because the truth is there's a lot about gender in the book and very little about gender in the talk. So I'm always happy to get this question. So gender is really important. So gender is very important in shaping youth exposure to violence in Central American sending countries. And then it's also very important in shaping their experience in the legal process and how they're treated by these different actors, these different helpers, and the different bureaucrats that process their case. So first of all, in the sending country, both boys and girls are definitely subject to child abuse at home, but in terms of their exposure to gang violence, the risks are very gendered. So it's mainly boys, it's mainly teenage boys who are targeted for forced gang recruitment, whereas girls are much more at risk of being the targets of sexual harassment, abuse, and even rape at the hands of gang members, so-called forced, like gang girlfriends. And actually, those cases, despite the fact that you could say this is a situation of domestic violence, right? Horrific domestic violence, those cases face special challenges as well in the U.S. asylum process. Because basically the idea of domestic violence is very much tied to kind of an intimate partner violence, right? That takes place within a household. And, for child abuse, that also kind of holds. It's within the household. The child caretaker relationship is one of abuse, and the child is unable to leave, or the woman is unable to leave this relationship, and hence is at risk of persecution in the home country and needs to leave. But with the forced gang girlfriends, many times the abuse and the sexual violence took place outside of the home. And so in some cases, the asylum claims were denied because of that. They didn't have enough evidence that this was really like an intimate partner situation, right? Despite the really horrific violence that they had experienced. Now, in the US, like the way that unaccompanied minors experiences are gendered is very similar to how migrants' experiences are gendered more broadly, right? Men, we know, are disproportionately targeted by immigration enforcement. So, and they're subject to these very criminalizing tropes and stereotypes. So this was very much the case for teenage boys as well. And in particular, they were criminalized as potential MS-13 gang members, right? So they had to work very hard to present a self that was very childlike, very innocent, and that couldn't signal them as gang affiliated in any way, which, all sorts of things were read as gang affiliated in potentially, right, in the immigration bureaucracy. So attorneys would tell kids something like, oh, don't wear your, metal chain necklace, because that could be a sign of gang affiliation, or don't wear a t-shirt of a certain color. Don't post a picture on Facebook with a t-shirt of a certain color, because that could be read as a sign of gang affiliation, right? For girls, it was easier to be perceived as kind of vulnerable victims in need of protection. And if anything, they were seen as well, again, so it was easier for them to be seen as vulnerable victims in need of protection, right? And they were less resistant to showing their emotions because of gender norms. in the immigration bureaucracy. So boys were very reticent to crying, right? They didn't want to seem childlike. They wanted to behave in a manly way. And so, attorneys had to do all this work to tell them, no, like you're a child. It's okay that you cry. Like, it's not going to serve you well to try to act like a man, right? Which is what a lot of teenagers do in this particular space, right? Because the asylum space is a space that flattens out human experience, right? You have to be this one-dimensional victim. There's no space for complexity or anything like that.
Thank you, Chiara. Another key theme of the book really has to do with, again, going back to the brokers and the advocates that you talk about. One of the things that you mentioned is this problem of resource constraint and understaffing compared to the high demand of clients. And this is true even in a place like LA, which relatively speaking across the country has a greater concentration of advocates. Can you talk about how that is impacting the process? You said a little bit about funding before, but what this means both for the advocates themselves as well as the minors that they're working with.
Yeah, I mean, LA was in so many ways a best case scenario for children's experiences in the U.S. asylum process, right? Both because, as you say, Shannon, like it is a much more resource-rich city. There's a long history of immigration advocacy organizations dating back to the Sanctuary movement. A lot of these organizations are really specialized in working with Central Americans, right? Or many of them are actually led by Central Americans and second generation children of asylum seekers and immigrants that came to the U.S. In the 80s. So, I mean, not only is LA well-resourced, but the resources are of very high quality. So the people who staff these organizations are almost all fluent Spanish speakers or native Spanish speakers. I met one attorney over the course of my fieldwork who didn't speak Spanish. And so, and they have the cultural competency as well to work with this population, right? As well. And finally, the immigration bureaucracies are more favorable, right? If we look at these national discrepancies, the asylum office and the immigration court in LA have much higher grant rates. So this was a really favorable situation in which to apply for asylum. So I always say that imagine if this story I told you today is so bleak in the best case scenario, if someone were to replicate this study elsewhere in a situation where you didn't have, for example, a democratic legislature that is much more likely to give more funding for legal aid organizations, and of course creates an anti-migrant climate, so people aren't not even maybe feeling comfortable to go to immigration court and looking for an attorney. Places where legal resources are much more scarce. Like this story would be even more bleak. And because really children can't apply for this, for asylum on their own. And I really think that adults can't apply for asylum on their own either, because it's an extremely complex legal process.
Thank you. In just our few moments remaining, I just would like to pose a question to you about the applicability of your findings for the broader immigration bureaucracy. We've learned a lot about what's working and what's not through the eyes of these young people, but there's many other categories of young people and other categories of migrants who maybe are traversing similar challenges. And so if you could just summarize for us before we close, what take-homes would you want us to have about why these findings aren't necessarily just specific to these young folks?
Yeah, I think in the policy recommendations that I make in the conclusion, they're really applicable to all individuals navigating U.S. immigration court, and particularly so to all asylum seekers. And I really make two key recommendations. The first of all is to establish a universal legal representation system similar to, the defense attorneys in criminal court, right? Because no one of any age can apply for immigration relief on their own. It's a system that has been, likened in its complexity to tax law. I mean, I don't know about you. I certainly don't do my taxes by myself. So this is really crucial because a lot of these people are not being denied protection because they don't qualify, but they're being denied protection because they face all of these barriers that make winning relief unattainable. And second of all, and I think that this is such a simple recommendation, but it's really radical in many ways too, is that I really think that asylum law should be interpreted widely enough to protect people who are fleeing life-threatening violence in their home country. And our current asylum process, and this is true for children and adults, could not be further away from the truth. And I think that all of the stories in the book that show all of the paradoxes and all the arbitrary ways that outcomes play out really shine light on this crucial limitation of our asylum system and dispel this myth, right, of the bogus refugee, right, of the person whose case is being denied because they file a bogus claim. I mean, in most cases, these cases are being denied because of the narrowness of our asylum law. So there's a lot of work to be done. And immigration attorneys have in the past been successful at expanding the refugee definition. So I try to retain a little bit of optimism that will continue to be possible moving forward.
Well, thank you so much, Chiara. We've learned a great deal. I encourage everyone to go and take a look at the new book and to learn about Chiara's new work, which you can also find about on her website. So thank you so much, and we'll close here.
Thanks for having me. It was such a pleasure.
Absolutely.